Hello, thank you for joining us this afternoon. My name is Joshua Curtis. I'm here with Beresford, and today we're going to be talking about probate. Now, if you have an idea afraid of a probate, do you need a probate? What is a probate? A lot of people are concerned about the time it takes, about the expense of a probate, and a lot of people just don't know what a probate is. So that's what I'm going to try and teach today is what is a probate from the 30,000 foot view. So, a probate is a process where a court gives a person the ability to act on behalf of an estate. And that person's title is personal representative or executor. And their job is to administer the estate. Now, people often think that because they're named in a will as the executor or personal representative, that they are already the personal representative. That's not the case. Until a probate is open, court case is open, commissioner is signed an order appointing that person as personal representative, they aren't the personal representative or executive. But that process doesn't take a lot of time and a lot of expense to get open. And if there's a will, you can speed things up a little bit. But there's sort of some timing issues there if there's a will or isn't a will to getting the probate open. But once a probate's open, the personal representative is given something called letters. It's either letters of administration or letters testamentary, but letters are the proof that that person is the personal representative. Then with letters, they can go to banks and get into bank accounts, financial institutions, and they can transfer vehicles, they can sell real estate, and do all of the work that they need to do as personal representative. Now, the work of a personal representative falls into 5 main categories. So I'm going to go through those briefly here today, and then in future videos we'll do things to explain, the different components of each of those 5 areas. So the first one is locating heirs and beneficiaries of the estate. So an heir is someone who would get assets from the deceased person if there was no will. And then beneficiaries are people who are named in the will. And you have to locate both sets of people. Oftentimes they're the same people. If someone leaves their entire estate to their children are probably both the heirs at law and the beneficiaries in the will. But they have to be located and given notice that probate is either going to be open, or if there's a will that probate has been open, it gives them the opportunity to appear and make some claims if they think there's claims to be made. That's the purpose of the law, to give notice. So the personal representative has to identify all the names and addresses of those people so they can be given notice. Usually that's a pretty easy task. The personal representative often is a family member, and these other family members are known people, and their addresses can be figured out. Sometimes, if someone doesn't have children, and maybe they didn't have brothers and sisters and no living parents, then it can be a little bit trickier to figure out who those people are, and B, the addresses for all. So first task is figuring out who they are, where they are, and then we can move into opening probate. And then once the probate is open, the first thing that they have to do is to secure inventory and identify any assets. So the assets of the estate could be bank accounts, could be real estate, cars, and then personal property. Sometimes there's different collections of things, there's jewelry, art, maybe. There could even be intellectual property. So a lot of different assets. So the personal representative's first job is to make sure those assets are secure and safe. They're not going to get ruined or have damage to or have be able to be stolen. So secure the assets. Then within 90 days of opening the probate, they have to create an inventory of those assets. And that inventory has the value of those assets on the date of death. And some assets will end up being sold, and so the value will get determined when it's a market sale. Market value will determine what the asset's actually worth, but the personal representative's job is to try and figure out what that asset was worth on the date of death. And that inventory isn't filed in the court case. It's available to heirs, it's available to creditors in some circumstances, but it's not made a public record. So the value of someone's estate and the types of assets that they have isn't made a public record through a probate. Now, some assets aren't included on the inventory, and that's because they're not part of the estate. So we think about assets in two big categories. There's probate assets, those are going to go through the probate process, and then non-probate assets. So an example of a non-probate asset would be a retirement account that has a beneficiary designation. The financial institution that holds that is going to follow the instructions that the person gave them on beneficiary designation. They're not going to care what is happening in the probate. That's irrelevant. They're going to follow the instructions that they're given, and they're going to distribute the money the way that they were instructed to distribute it. So, the first thing in thinking about the assets of the estate is to figure out which assets are actually probate assets and which assets are non-probate assets, and we don't need to deal with them in the probate. And usually the personal representative is a person who's sort of helping act on behalf of the family and dealing with all of these things. So often the personal representative also deals with non-probate assets, but they wouldn't be required to do that. The next thing that they have to do is identify and pay creditors. So we think about creditors in two categories as well. So first are known creditors. So these could be a bill that comes in the mail, a credit card, a mortgage. Those are dealt with a little bit differently. So any known creditors, or it could even be someone who has a potential claim against the deceased. So for all known creditors, you mail them a notice to creditors. And once they receive that, they have 30 days for filing creditor's claim in the probate. Once a creditor's claim is filed, the personal representative has 30 days to either accept or reject that claim. They can also just pay the claim, and it's the same as accepting it. If they reject the claim, then that creditor has 30 days to file a suit against the estate to prove why they think they're owed the amount of money that's in their claim. For some creditors, we don't give creditors claims. Things that are low dollar amounts, oftentimes it's easier to just pay those than it is to go through the process of mailing a creditor's claim and then dealing with the claim as they receive it. And then mortgages or car loans. Something that's going to be paid off when the asset is sold doesn't need to receive a notice to creditors. It's going to be paid as well when the asset is sold. And then the second category of creditors are unknown creditors. So to deal with unknown creditors, we publish in the paper in the county where the person lives that same notice to creditors. And then it runs 3 times over a 4-month period. And during that time, creditors can make claims. So once the 4-month period has passed and 30 days have passed from mailing to known creditors, then the creditor's claim period ends. That's an advantage of doing a probate, is you can shorten the creditor's claim period down to 4 months. The law says that if the personal representative has made a diligent effort to find reasonably ascertainable creditors, then the creditor's claim period ends after that has been done. Then the personal representative can feel more comfortable distributing assets and going about finishing the estate, knowing that they're not going to have someone pop their head up and have to pay it out after that. So the next category is paying taxes. So there's 2 taxes that we think about here. The first is income tax. The personal representative has the authority to file an income tax return for the deceased. So if there's taxes that are owed, they pay the taxes. If there's a refund, they can file a tax return with the refund. And the second type of tax is estate tax. There's a Washington state estate tax and then a federal estate tax. And each of them have different rules, different ways of treating gifts that were made during their lifetime, and then also different exempt amounts. So, and that the law changes. So the important thing is when someone passes away, that's when you need to figure out what the current exempt amount is. What the value of the assets in the state are by the inventory that you've done, and then you figure out if an estate tax return needs to be filed or not. There are some circumstances when an estate tax return could be filed even if estate taxes aren't due. That's sort of a case by case basis. It's something that you work with CPA or an attorney on figuring out if it would be advantageous to file a tax return, even if there aren't state taxes due. And then the last piece, which sounds really simple but is a lot of work, is distributing assets to heirs and beneficiaries. So the personal representative can liquidate assets, so they can sell something like a house, they can get money out of bank accounts, deal with an estate sale or whatever they need to do to deal with all the personal property assets. But some assets can't easily be divided between multiple people. For example, if someone leaves their entire estate to their 3 children, and most of the money in their estate is the value of their house, probably the house is going to have to be sold. So the personal representative goes through the process of selling those assets, receiving the money back, putting it in the estate account, and then redistributes mostly money at the end of the probate. Now, the personal representative also distributes personal property assets, the things that someone owns. And a prudent personal representative is going to keep track of those things that they distribute to different people and assign a value to them. Back to my hypothetical about if someone leaves their estate equally to their 3 kids, if someone gets the car, then that should be taken into account, and the value of that car should be part of that person's share of the estate. A lot of times, the personal property assets have already been distributed, maybe even before a personal representative has been appointed, before probate's open, and so that can be a little bit tricky. For most families, they generally don't pay. They're not looking for it down to the penny accounting of it being equally exact equal shares. But some families that is important, and so the personal representative's job is to figure out what those assets are worth, assign a value to them, and then account for that when they're distributing the assets. A personal representative can also make preliminary distributions. So a preliminary distribution would be a distribution before they're ready to close the estate. And oftentimes this could happen when maybe the house has been sold, the bank accounts have been consolidated into an estate account, but a tax return still needs to be filed, or there's some piece that still needs to happen. So if the personal representative is comfortable holding back enough money to deal with whatever that thing is, tax return, paying themselves as personal representatives, paying the final attorney's fees, closing out the estate. If they have enough money to do that, they can make distributions to the heirs in advance of closing the estate. They don't have to, but they can. So then once the entire estate has been dealt with, all the financial accounts have been dealt with, all the assets have been handled, then it's time to make distributions and close the estate. So the personal representative can make those distributions, close bank accounts, do the things they need to do, and then their authority as personal representative goes around. The work of being the personal representative is a lot of work. And a lot of these things that a personal representative does are present whether this is in a probate or not in a probate. Even if someone had a revocable living trust, they avoid a probate, but a lot of the work still has to be done. The house still has to be sold, the bank account still has to be dealt with, the calculation of distributing assets to the heirs and beneficiaries still has to happen. So when someone says, should I avoid probate, that's an okay goal. It saves time, it saves some money, but most of the hard work still has to be done. So probate in Washington takes on average 9 months. Washington is a state where the personal representative can get paid a reasonable fee for their time that they spend working on the estate, and the attorneys get paid based on the rate and time that they take. In some states, it's based on the value of the assets of the estate. So in Washington, probates aren't particularly expensive. They're pretty efficient on time, and most of the work, like I said, still has to be done, whether it's done in a probate or outside of the probate. So thanks for listening today. And in upcoming videos and posts, we're going to be sort of putting some more detail into each one of these categories and explaining the things that are part of most probates, some things that are unique to only certain probates, but trying to show more detail on how the personal representative goes about doing their work and administering the estate. Thank you for listening today.
you.